Welcome. This is the SCORE workshop for intellectual property, or as what our speaker, Doug, calls IP, and small business legal concerns. This is the SCORE workshop, and I just want to let you know that SCORE has been around since 1964. It's a national organization and is completely made up of volunteers, and they're a resource partner for the Small Business Association. And the mission is to give every person the support they need to thrive as a small business owner. And we do this through mentoring and workshops like we're doing tonight. It is all free and an excellent resource. So if you'd love to have a mentor, if you're stuck on a problem, want to create a business plan, there are experts that can help you. And you can go to pmot.score.org for more information. But we're glad that you joined us tonight. We will get started here in just a second, but I just wanted to let you know, please do ask questions. Our speaker, Doug, is totally receptive to you asking. If you just want to put a question in the chat area, I'll try to unmute you. This is my first time running Zoom, so I'm still got my training wheels on. You should have received your handouts in the email that I sent to you. So hopefully check your email if you did not. I sent those later in the day. And at the end, we'll have a poll just to ask for your what you thought of the evening. So we're so glad that you're here and that you've joined us. And we're also very delighted that Doug Lineberry has offered his time tonight to speak on his expertise. He's a lawyer and a partner with Burr, Foreman, and McNair. Is that right? Yep. In Greenville? Yep. Okay, and he's here in Greenville. His specialty is intellectual property. He is a specialist with patent, trademark, and copyright protection. That is a lot of stuff. And I noticed, I looked him up on his firm's website, and he's been recognized as a best lawyer in America for litigation for intellectual property. So we have the best tonight. We are very fortunate. So we appreciate your time, and we would want this to be interactive, so please do ask questions, but we're glad that you've joined us. So with that, I'm going to hand it over to Doug.
Absolutely. Now, everybody, do feel free to ask questions. What we're going to do right now is I'm trying to share screen, so bear with me. Maureen, can you guys see the one that says do's and don'ts for inventions and trade secrets?
Yes, we can.
Excellent. All right, everybody, you should have this presentation, but don't get caught up taking notes on it. I do want y'all to ask questions. Again, this is my Marine's first rodeo, so bear with us if we hang up on you, but I promise we'll be back. But I absolutely want everybody to ask questions. One thing, too, feel free to call or email me, and Marine will tell you, and the other SCORE volunteers and the SBDC folk as well, I love helping small businesses. You guys are the cornerstone of American industry. Everybody started off as a small business at one time. Whether you're now known as Microsoft or BMW or whomever, we all started off small. You know, I started off as a baby attorney back in '98. I couldn't even spell most words that I deal with now. But I want y'all to know that this is a very laid-back situation tonight. I want y'all to leave it educated, and I want you to always feel free to reach back out to me or Maureen with questions, because I would much rather you ask than guess, because you know, where we're at tonight is we're looking at things such as the mistakes people make. You know, what happens that goes wrong, because obviously the ghoul in everybody wants to know what the horror stories are. But what I want us to understand tonight is that everybody here who has a business has IP. And we'll try a little thing right now. Who here has their own business? If you would, just kind of, let's see how the polling situation works. Let's see how that works for us to be able to see who's got their own business. I see a Tina raised a hand. I see 2 participants raising hands. Good. We're getting this out. Awesome. 6. Awesome. So everybody here has their own business. So guess what, guys? This all applies to you. And I know you're thinking right now, it's like, you know, I don't know what this guy's talking about. You know, how do I have any of this stuff? But the first thing we need to understand, and Maureen, can y'all see the mouse moving on the screen if I do this? Yep. Awesome.
Yep.
And so what I want y'all to know, Q&A, sorry, y'all, I'm easily distracted. I'm a Captain ADD. So I've now figured out where the, now we're up to 12 participants, you poor souls, and I can see all your names. So Marvel Murray and Henry Davis and Karen and Craig and Jasmine, John, Lindsay, Marvel again, wow, doubled up. Michael and Tina, please ask questions. If you just joined, you're not bothering us in any way, shape, or form. But what I want us to know tonight is that everybody here has this IP we're talking about. This is not some sort of esoteric academic discussion. This is real world. And one thing I want us to all be able to do tonight is to understand that, hey, failing to understand that I have it is a critical thing. Sometimes it can be critical in the sense of we lose the ability to protect it if we're not careful. One thing I want us to realize too is that getting to the market early is awesome. Getting there with the IP intact is more important. I also want us to realize that, hey, we might think something's a copyright when it's a trademark. We might think something can be patented when it should be a trade secret. By the end of tonight, you will have at least a good grasp, or I will totally confuse you as to what those mean. But what I do want y'all to do is to understand that, hey, everybody who raised their hand about a business, you're here because this applies to you. You're here because this deals with you day to day, every hour. I want you to be excited about this. You know, guys, guess what? It's awesome that all of y'all are business people. It's awesome that you're all small business people. It's awesome that you're all working Marine, because this is a great place to be. And as y'all seen from the economy lately, things are still gaining steam. Things are looking good. You guys are the forefront of it. You know, that's why you're here, and that's why you're doing your business at this point. But first of all, I want you to understand that if you talk about things too early, if you get a little too excited, bad things will happen. We can lose our patent rights. If we talk to things a year out, if we say, like, we're on a Zoom call with somebody, and let's say I hold up my brand new widget invention, I'm looking for something on my desk to hold up. Let's say we hold up the brand new invention and we're talking on a call like this, guys. This disclosure tonight at 6/13, year of our Lord 2020, September 10, you can lose your rights. If you wait a year before trying to protect those, they're gone. And it's as easy as holding something up on a Zoom call and explaining it. You know, I'm not saying, hey, a quick glance and it's done. But if I hold this thing up and start explaining how to make it, how to use it, what it's made from, yada, yada, you can lose your property rights. I don't want that to happen for anybody. By doing that disclosure, you can trigger mandatory deadlines. The U.S. is pretty straightforward. If I hold this up and I talk to you about enough to disclose how to make it, how people use it, we have 1 year, 365 and a quarter revolutions around that great big yellow orb. If we don't file patent protection before that, we can't file it ever again. We're done. We made a public disclosure. It's out there. Before I jumped on the call, I'm working on a patent application. It's got to be filed before Saturday. We have some inventors over at Prisma came up with a really cool invention. I can't tell you about it because we haven't filed on it, but it has to be filed Friday because Saturday they're going to be doing a massive presentation on the Blue Jeans platforms like Zoom, different program, but they're going to be presenting to people across the U.S. And if they hold up their widget and they talk about their widget enough on Saturday, they can trigger those deadlines. A critical thing is, though, you lose the ability for foreign protection. You know, my holding this up and talking about my invention, I can't go to Japan, I can't go to Europe, I can't go to Canada, I can't go to Mexico. By holding it up and talking about it in this public forum, we've lost it. I don't want anybody here to do that. I want you to think about, hey, if I need to talk about an invention or if I need to talk about a new way of doing business or something I've developed, I want you to have a little hesitation before jumping on the Zoom platform. I want you to understand that, hey, words have dire consequences in the sense of IP, and I don't want you to lose it because we were excited about it. Also, you'll see this prior art. That's a term of art really in the IP world. But what it means is that you can be your own worst enemy. By holding this up and talking about it, if I don't file within a year, and let's say that I put, you know, in addition to, you know, us having video tonight, you can see my screen. Let's say that I put the specs of this bad boy on there. That can be used against me at the patent office. And they can hold up my own work to say, hey, you know, I see that you're trying to protect this, but I've got this disclosure back from September 10th of 2020, more than a year before you filed, and it's that device. So you literally can become your own worst enemy. I don't want any of you to do that. Also, trade secrets. Everybody in here is like, I don't have one. I promise you, we all have one. You know, Maureen has a side hustle. She has trade secrets for that. I, as an IP attorney, have trade secrets. Most of it is my shooting my mouth off like a cannon, which isn't really a secret, but you guys get the concept. But like my client lists, my pricing, you know, where I go to market, how I find clients, ways that I protect IP, those are all trade secrets. You know, Lindsay, and I told y'all I'd call on you, so it's coming, we're warned. Lindsay, Karen, John, if y'all have a pricing list, if you have a list of expansion plans, if you have product development schedules, all of those are trade secrets. I don't want us getting on a Zoom call and ever discussing trade secrets. That's a bad plan. I don't want us going to Clemson or USC or Coastal or Anderson or anywhere else and standing up and talking about our inventions in respect to their trade secret protections. We don't want to do that. Instead, what we want to do is we want to have reasonable protective steps. Reasonable is a court term, so why I've got it quoted. It's the he or she in the white dress that decides whether you were reasonable. Things that are considered to be reasonable: locked doors, password access on computers, restricting third-party access. Had a client a few years ago, I won't embarrass them by saying the name, but I'm in Greenville and they're really close. And they unfortunately admitted a certain group, you've heard of them, they rhyme with Apple. They showed up, went through the client's procedures, went through the lab, went through everything, and my guys just were amazed. Oh my gosh, Apple wants to talk to us. That's a nightmare scenario. What happened was, about a year later, Apple had filed a very similar patent application to what the client did. The client was nowhere near as big as them. They can't fight them. They can't protect this stuff. But my client goofed up. They let them come in. They let them see it. And all of a sudden, they're like, Doug, what do we do? I'm like, well, foremost, I wish you would have called me before we gave them the guided tour, because I don't want any of y'all doing that. That is a trade secret. The way your business operates, whether in the physical sense, a business sense, or an economic sense, are all trade secrets. They're never going to be anything other than that. If you have documents that have trade secrets in them, guess what? Label them. Put the great big red watermark on them. Let folks know that you're taking care of this. Let folks know that you're the person who knows what's going on, and you don't want them, meaning third parties, to be able to take advantage of this.
Doug, we have a question. We have a question.
Absolutely. What's the question?
Okay. From Tina. Doug, if you have individuals sign an NDA regarding your idea invention, will this completely protect you?
A great question. And if whatever is covered in the NDA can be protected, you want to make certain it's a good one. We also want to make certain that it's an NDA for appropriate things, because I would never advise that you tell a trade secret to somebody. Your pricing, your expansion plans, the way that you make something, all of those may be trade secrets. Especially in the chemical arts, if you've got a brand new a fragrance, or maybe you came up with a new Coke, or maybe you've come up with a new cookie, all of those can be protected via trade secret, possibly with patent. So an NDA is something that I'm glad you asked. Yes, absolutely use them. If somebody refuses to sign one, hit the trail. You do not want to be dealing with somebody who won't sign an NDA. And I realize you're like, but I want to talk to them. You might just be able to talk to them at an 80,000 foot level. If they won't sign an NDA, we don't go into the grass and start talking about how we make the widget. We're not going to hold the widget up and explain it to these people, because their refusal to sign that is not a good thing for us. But yes, an NDA absolutely can protect you. You want to make certain, though, that you're disclosing NDA coherent material, that we're not disclosing trade secrets. I would prefer that a trade secret never be disclosed unless we're talking about a buy-sell of a business. Does that answer your question? Cool. I will take silence as a good thing.
I think,
but
yeah.
if y'all have any more, please absolutely ask. You're not interfering one little bit. I'm glad that y'all are asking questions.
She did say it does. Thank you. She said.
You're more than welcome.
Thanks,
and
Tina.
Please do it again. Now, guys, for our mishaps for these inventors and for inventions, a big thing, and you'll hear me say the word assignment a lot tonight. If you're working with anybody, and it can be a single person, it can be a cadre of people. But if you're working with somebody and y'all come up with an invention, or if you come up with a copyright protectable item, which we'll go over in a little while, I want you to understand that just because you pay somebody for something or pay somebody for that work doesn't necessarily mean that you own it. You think you do, because you're like, hey, I paid good money for Smith to help me out on this, or I paid good money for Jones to help do something. But think of it in this aspect. If we hire somebody who's going to help us on an invention, we want to get an assignment from them so that we know who owns it, that there's no issue who is the owner of anything. Because if we don't obtain an assignment from somebody, we come up with ownership issues. Ownership issues are bad in the patent world, because let's say that you put two names on a patent, Jones and Smith. If we don't have that assigned to your company, Henry, your company, or Karen, yours, or Lindsay, or Marvel, yours, if it is not assigned to your company and they're just two names on that patent application, once that patent issues from the patent office, they're considered equal and opposite owners. So let's say John and Karen, you guys were in a business together. you filed for this patent jointly, something happens and you go sideways with each other, at the end of it, you guys can sell your half of the patent to whomever you wish. And I don't want that happening to anybody here. I want there to be an assignment to go to an LLC or whatever your business entity is. Because first of all, that's where we want IP to reside, in a business entity. We very, very, very seldom ever want it to be a personal asset. I can't really think of a good example why, unless maybe you had to do something on a rush job, you didn't have an LLC set up, and it had to be in your name. But that alone should be temporary. It should later be assigned to your company, because guess what? Later on, when you decide to divest this company or maybe sell it, or somebody wants to buy it from you, they're going to ask these questions. They'll send in a Doug or a someone else, or maybe a Marine if she's a consultant on this issue, to say, hey, what have you done with your IP? Where does it reside? Who owns it? And if there's an assignment issue with it, that's terrible. But if it's just in your name personally, we can take care of that and have it assigned to the company. But we never, ever want to have a situation where we're unclear on who owns something. Also, guys, if you have patent deadlines, they are rock solid. If you miss that date, you're done. You might be able to file and have it brought back to life, but there's also a critical damage done to those patents and those things. One thing I do with my assistant every week, and y'all will hear me mention Laurel several times, we do a docket meeting, and we go through everything that's due. We go through every date. We go through what it is, whether it's a patent, a trademark, a copyright, or whatever. We go through it to make certain we know what dates are coming up, and that I'm prepared to meet those dates, because that's part of my job. And that's why I tell you too, don't go cheap with IP. I know it's an attorney saying use an attorney. I'm going to say it again. Use an attorney for patents and trademarks. Copyrights, I can kind of show you how to do that on your own. If you're an artist, if you're somebody who designs like jewelry, if you're a photographer, if you're someone along those lines that creates a lot of original content, you want to learn how to do your own copyrights, because it saves on legal fees and you can do it fast. It's just a matter of going to uscopyright.gov. Once you learn how to do it, if you're technologically capable of uploading a JPEG, you've pretty much mastered the Copyright Office. There's some questions that go with it, but it's simple stuff, nothing outlandish. But what I don't want you guys to do is to go to a LegalZoom or one of these fly-by-night places you see on the internet, because all they really care about is getting that money. And after that, they don't care at all. And guys, they may get you a patent, but it will be an atrociously broad patent. It will be a bad patent. It will not be a good patent. And you will notice that their fees will be much more than if you just went to an attorney straight out. You know, you hear these horror stories all the time. If somebody will say, hey, I paid $11,000 for something and I don't even have a patent filed yet, that's outlandish. That is just crazy talk. The reason you want an attorney too is, guess what? If Marine's my client, she knows where I'm at downtown. And yeah, COVID and the age of nobody's in a room together, we're all elbow bumping, she can still track down and kick my butt if she has to, because she knows where I'm at. She knows that she can call the bar on me if I end up being a scumbag and don't take care of her. But with LegalZoom, these guys are probably in another state. They probably have you sign a waiver that says, hey, for that $11,000, you're going to get nothing. And you're going to be happy with nothing because you signed this agreement saying you're going to get nothing. So I want you guys to be very, very wary of those. I get that they seem so cheap when you see them, but it's kind of like you get what you pay for. One thing, too, to go back to, trade secrets. Everybody here has them. Craig, you got them. Henry, you got them. Robin, Tina, Marvel, Lindsay, every single one of y'all have trade secrets. I'm not overstating this. You absolutely, positively have them. Whether that might be pricing, whether it might be where you source your materials, where your business is going to next, how you're going to market. That could be your trade marks that we'll talk about in a little bit. It could also be like your recipes and formulations. You know, maybe you're a chemical company. One of my clients is Charleston Ice Cream Company. They have a very cool, and I say program, but it's not. They have a very cool recipe on how to infuse ice cream with alcohol. And they figured out how to do it in a very concerted way so that they don't melt the ice cream, which is kind of an important thing in the ice cream business. They did not file for a patent, because to do that, when you file for a patent, you have to explain everything. Now, when you're holding up that invention to the patent office, you have to explain all about it. You have to say how to make it, what's it formed by, how's it best made, what does this best, what does that best. If you don't do that, you may not get a patent because you've not disclosed enough. But what I want y'all to do is to realize, hey, you know, recipes, formulations, chemical formulas, those are trade secrets. You know, you can't really get a patent on a recipe, and you don't see Coke going to get a patent on their soda because guess what? It's really, really hard to reverse engineer. You go to Publix, you go to Bilo, you go to Kroger, whatever your local store is, you go down the aisle, you'll see all the soft drinks that are there. And you will always see that funky red bottle that kind of looks like Coke, and it's caramel covered and it's in a red bottle. And they're trying to look as much like Coke as they can without the boys in Atlanta getting upset. But if you drink that stuff, it never, ever is Coke. It's never going to be Coke because it's really hard to replicate that. And Coke protects that formula to the nth degree. Only 2 people in the company know it. They don't even fly on the same planes, guys. They take it pretty seriously. One thing.
Doug,
yes, ma'am.
Okay. We have a question from Henry.
Hey, Henry.
I think he's talking about the NDA. Does this apply to a contractor hired to design a product? Does an assignment need to be obtained?
Great question. Henry, the perfect answer. Your NDAs work with them as far as those initial discussions, but once they're working with you on something, and whether they're helping you generate code, if they are, you want an assignment for that. If they're helping you generate something that may become a trademark, if they're an artist helping you design it, you want an assignment on that. This is like a dangling Chad. All we have to do is get an assignment, and it's not an issue anymore. Because guess what, Henry? You'll own it, or preferably your company will own it. Yeah, you do want somebody who's bringing in as a contractor. A lot of people think, hey, work for hire will protect me. Work for hire, and you've all heard it. And you've heard, and think what else, the other horrible terms that we'll cover tonight. Work for hire, fair use. There are a lot of copyright terms that people bandy about, and they don't mean what you think they mean. For you, work for hire means literally it's got to fall within these very particular weird exceptions that nothing ever falls in, or it needs to be in a writing signed by both parties, basically stating, hey, this is what's coming to me. But if you're going to do that, get them to assign it to you, because I would rather have an assignment, like if I hire a Marine to help me develop something, we're going to file a patent on it. I don't want there to ever be an issue. Who owns this? I want it to be Doug Inc. or Marine Inc. or whatever the company is. I want it to own it. If we don't circle back to that, though, Henry, we run the problem of, hey, maybe a patent comes out, you're both inventors on it. If it's a copyright, it's a little bit worse. And this happens a lot of the time in the copyright and trademark realm because, guys, everything unites in a spear. It's kind of one of those overlapping Venn diagrams. These are not separate from each other. Trade secret can absolutely interlap with the others, even though we never talk about it. A patent can absolutely have a trademark associated, a copyright, and trade secrets. So we're not looking at very distinct quantity units. We're looking more like an amorphous flow here. Sometimes you're heavy patent, but there may be a copyright tangent. There might be a trademark tangent. There might be a trade secret tangent. But Henry, if you have somebody working for you, I want you to assign to your company whatever they're doing for you. Because here in the copyright realm, let's step to that for a second. I hire a Marine to make a logo for me. I have what's my company? I have a suntan company. And Marine comes up with a beautiful logo. It is awesome. And she and Jennifer are working together on this thing. And so they work for me, and I pay them $500. This is awesome logo. It's just so cool. Everybody's going to tan with me just because of this logo. Here's the problem. I did not get Jennifer nor Maureen to provide me an assignment. Now, in copyright realm, that's a horrible thing. It can't be any worse. In trademark realm, it's a horrible thing. It can't be any worse. Because what has happened is I own the one version that they gave me. My $500, which is a lot of cash, and maybe they charge me $5,000. But if I do not get an assignment from them, Maureen and Jennifer still own the copyright in my trademark. And you're like, that's weird. What's it mean? Concrete example. Greenville had a very popular kennel several years ago. They went to an artist, went to a Maureen or a Jennifer, had them do a logo for the kennel, and I think it was a Cocker Spaniel. I always get the dog wrong, so there was a dog. They had Maureen and Jennifer design this for them. They did it. The kennel paid them for that work, but did not get an assignment. And so here's the problem. Maureen and Jennifer later on say this kennel's very popular. They're everywhere. They're internet. There are several concrete locations. It's on cards. It's on brochures. It's everywhere. This dog was popular. So Maureen and Jennifer rightly come back and say, hey, kind of like a wedding photographer, because that's the best example of this. You only paid for that one iteration. You paid for that one picture for the dog. You did not pay to use it on your website. You did not pay to use it on brochures. You did not pay to put it on the front of your building. Those are copyright derivatives. And yeah, we're using it as a trademark. But guys, Jennifer and Maureen own that unless they assign it. If we don't get an assignment from them, whether it's patent rights, copyright, trademark, they still own it. So let me drive this point home with a nail. We want an assignment from anybody working with us. And yeah, maybe it's belt and suspenders, but I tell you what, if you come to me or one of my brothers or sisters and say, hey, I'm now in a conflict with Smith or Jones, first question out of somebody's mouth is going to be, where's the assignment? What did you do? And if you can only say, well, I gave Maureen money, I gave Jennifer money, that doesn't count, guys. All that does is buy you one iteration of it. And what happened with the kennel was they went to court and they said, hey, judge, we paid Maureen and Jennifer money and we know we own this. The court said you own the one iteration, you owe them royalties on everything else. The kennel actually went out of business. And so y'all need to understand these do have real world implications. Now, we're not talking about high level ivory tower stuff. We're talking about things that can lose your business. For the patent realm, horrible case from 2016 from North Carolina. A company up there around Raleigh in the Research Triangle hired this MIT inventor to work for them. He was an independent contractor, Henry, so we're all still in the same game. He was very proficient at what he did. He generated upwards of 25 patents for them over the span of like a 4 or 5 year course. And what they had promised him was that, hey, you know, we're going to pay you a bonus for each of these. And I think it was $10,000 per issued patent. He got like 32 or 33 out. So they owed him a big chunk of money, you know, roughly, you know, $250,000, give or take rough math. But problem, Henry, they never had him assign it. And so the inventor comes over, rightly so, and says, hey, I want my check. You know, you owe me a bonus on all these. I just want my money. They fired the guy. So, you know, he's understandably upset. He went and found an attorney. So attorney turns around, and not only do they look at this and say, well, yeah, you were definitely owed that bonus money, but they never had you assign anything to the company. So he owned every one of those patents. He was the sole inventor. There was nobody else on it with him. At the end of this little nightmare scenario in North Khaki, the company did not own any of the IP that they based their business on. It was all owned by that inventor, guys. So this, and again, rock solid case, 2016 nightmare scenario, could have been fixed with one piece of paper, an assignment from him to them for everything he did. But he wasn't an employee, and there wasn't that ability to say, hey, this is the course of his duties, blah, blah, blah. They're like, nope, this guy's always been an independent contractor. And because they tried to screw him out of, you know, roughly a $250,000, they lost their entire company, and should have. I mean, that's just what should happen to dirty people. But guys, I don't want that to happen to y'all. I'm not saying anybody's a dirty person, but you can avoid these nightmares with an assignment. It's a simple thing to do, and it's omitted so often.
Henry has a follow-up in the chat area, and then I have another question from Tina. This is the first time I've heard of an assignment. What would the process look like to do this? From Henry.
It's pretty simple. You'll call your attorney. It does have to have special magic language. Do not, and this is going to be another big admonition for everybody, if any of you on this list, the 10 attendees I have, and I'm talking Henry all the way down to Tina, you're currently on the bottom. If any of you pull a document off Google and use it, I don't know you and Maureen doesn't know you. We will literally see you in the store and turn around and walk away. Do not pull your legal documents off of Google. We don't know where they've been. We don't know what they were framed in. And I hear you, Henry, you're like, hey, I'd love to do this on my own. You can, but if you do it wrong, you're in the exact same situation as our North Khaki friends. If that assignment is not done, like one of the things has to be present tense language. You can't say they're going to give it to me. They promised to give it to me. They swear, pinky double swear they're going to give it to me. We can't say that. It has to be done very precise, special language. All right, Maureen, next question.
From Tina. Doug, and in addition to an NDA, do you recommend having individuals also sign a non-compete agreement as well?
That depends. Tina, that's a great question. You know, what are they doing for you? You know, you don't have to tell me your life story, but what business are you in? Aha, Tina's jumping on. And I'm sorry, I've got to watch me make weird facial motions. I'm hoping you just see my slides.
She says education. Sorry, I muted myself.
Excellent. Excellent. Okay, so for an educator, sure, you can use a non-compete with somebody if they're an employee, or if there's somebody that you think could be critical. A few issues with non-competes, magic language. Just like I told Henry, do not pull this crap off the internet. You'll want to, That is a very bad impulse to have. South Carolina is actually, you can use them in South Carolina, but guess what? You can't in California. You know, in New York, they're different. Guess what? You go down to Florida, what they'll allow you to do is different than what we allow you to do here. Georgia, North Cac, South Carolina, all in the same cusp of it. You head over to Tennessee, it gets weird. So what I want y'all to understand is, yes, you can absolutely use a non-compete agreement, but it has to be narrow in its scope. And I mean that in a temporal sense, like how long it lasts, as well as a geographic sense, meaning what areas it covers, as well as a general scope of what is verboten. Because if you say to somebody, you know, Tina, if you say to whoever this employee or independent contractor is, you can never work in education again anywhere on earth, I'd sign that all day long because it's not enforceable. You know, and I can sign it, and I'll sign a stack of them, and I'll give them to you, and I'll be like, yep, I signed that non-compete. And then I'll go out and start my own business because you're not going to be able to enforce that one. But if you state one with this person that says, hey, within a select few zip codes around where you've worked for me, you know, you can't do this particular aspect of what I had you do for a span of, say, 18 months to 2 years, good chance you can get that enforced, and enforced day in, day out. And again, when you want to, you know, there's that whole tendency, you know, remember this, pigs get fat, hogs get slaughtered. If you make that language too broad, it's going to come back to haunt you. But if you narrowly tailor it to what you need to protect, much better chance that it'll be supported. But great question. If you do have the ability to use the non-compete, I suggest that you do that.
One more question, Doug, from
Sure thing.
Michael. How much
Hey,
are
Michael.
the legal fees for something like an assignment?
Sure. Pretty basic, you know, about an hour's time, no big deal. You can run that to be between like $300 and $400. And again, you'd want your attorney to give you a Word version of it, which I do, because guess what? You know, once you've got that thing, it's good for a few years. They don't have these cataclysmic big changes. You know, if they did, you know, you'd want to be aware of that. But typically, once you've got a good assignment, if you've got a plethora of employees, you'll pay that one fee and then use that thing for the rest of them. You do want to make certain, though, in that assignment that you don't get lazy, that you do put in there, Michael, what they're assigning. Like if you've got a project description, you know, if there's a way to make an attachment to the assignment to say, hey, you're giving me this. If like Maureen's your artist on this one and you're having her assign the copyright to you, you want to be able to show the attachment A is, hey, here's the picture that Maureen did for me. I now own this in fee simple. Legal term means you own it. Nobody else can have any claim to it. Great question. You know, and y'all are asking, okay, Doug, you're scaring me. What's the worst thing that could happen? Don't enter into handshake deals with anybody. Handshakes turn into fistfights immediately. It's just a bad plan. I mean, guys, I've seen it over the years, and y'all can tell from this gray hair, it's not cosmetic. It's just stress from my kids. But I've been around enough to be able to say, hey, I've seen fathers and sons turn on each other. We don't want that to happen. If you have a business deal with somebody, it's in writing. Again, let me say that slowly. It's in writing. And I do mean a sign writing by both parties that details things. And I don't mean one of my sticky tabs here in the office that's got a couple lines scribbled on it. I mean a fully fleshed out document that explains your relationship, expectations of one another, and termination of it. You know, what happens if we become worst enemies? Those are the critical core terms that need to be in there, plus other factors. But guys, if you don't do that, that's a problem. And you'll come to an attorney, and we'll try to help you sort through that going backwards, but plow that field first. Don't come to us after it's already overgrown with weeds. Do that at day zero. Assignments, assignments, assignments. I told you, y'all hear this word a lot. If you don't get assignments, Maureen and I don't know you anymore because you've been warned. If you hire people to make product for you, to design things for you, and I'm talking statues, plans, logos, you know, schematics, anything along those lines, guys, there can be a copyright tangent to those. And again, we'll go into that more specifically in a little bit. But I want you to understand that those are omnipresent. I don't want y'all thinking, oh, you know, I don't really need an assignment. You do, or you might lose the company. Also, a competitor beats you to the punch. He who hesitates is lost, guys. If you have something you think can be patentable, you know, everybody wants to think, oh, well, you know, I'll wait till I've got the money for it. They're economical things that we can do. You know, there's a thing called a provisional patent application. I follow those a lot for small businesses because what it does is it helps us allay costs. Patents are expensive. Patents take a long time. You know, provisional lasts a year. And you're like, oh, yeah, that's a year. You know, is that long? Is that short? Anybody here with kids knows a year is gone. You turn around, year's over. You know, here's the U.S. Patent Office saying, hey, time to file a utility application, which will be examined. There are ways to break these costs out over time. I love doing that with folks. You want an attorney that will work with you on that. I want you to ask for that Because, guys, one thing Americans are bad at is negotiation and haggling. For some reason, we've lost the skill. But I want y'all to understand that contracts are meant to be haggled. You know, your contract with your attorney is meant to be haggled. Go in there and ask, what can you do? How can we do this? Can we structure things differently? There are a lot of ways to skin cats, but if you don't ask, you'll never know. Also, capital. Guess what? Everybody here is a small business. Everybody wants more capital infusion. If you don't protect your IP, the venture capitalists are just going to giggle. All of us have seen Shark Tank. You know, we've all seen when people roll in, and the people that they take most seriously are the ones who say, yeah, I have filed a patent on this. I have a patent pending on this. You know, I've got a design patent on the look of this and a utility on how it works. Those are the folks who are doing it right. The folks who roll in off the street and are just kind of la-di-da, they're in trouble because A, they might have violated some of those time deadlines we talked about before. Those haven't left us. But also B, it shows a capital person that, guess what? This may not be the person that you want to trust with money. You know, if they've not thought about IP in a tangible, concrete protection sense, they're probably going to treat their business the same way. And giving you a venture infusion is kind of like giving a junkie another fix. You know, it may not end up the way you want it to. But if you roll in and can say, hey, I know what I have. I've got it protected. I've got trademarks to cover my branding. I've got my patents filed. I'm pending. I'm right now working on those. Guys, that's awesome. And a huge thing, everybody hates hearing this, have a prototype. If you have a widget, if you have a machine, if you have a binder clip that I've been holding up all night, I want you to have a prototype. You don't have to have that to file the patent, but it makes it a lot easier because guess what? When you know how this thing works, and I can't even open it, it's been a long Thursday, but you see how this thing functions and you see what it does, if you can show that to a venture capitalist and they can put it in their hand and touch it, that is 1,000 times better than going, here's my patent, let me explain this to you. That's not going to work. And nobody likes to hear that, hey, you have to have it embodied, because the patent office is like, you absolutely don't have to, but a venture capitalist requires you to, because you're going to them asking for money. If you're talking all wishes and fishes and dreams, you're not walking out with anything. If you walk in with this bad boy and show how it functions, and you show that it's sturdy, and you throw one at them, and they can sit there and hold it, guys, that helps so much better. So prototype, prototype, prototype. Also, if you ever have a contract, don't you ever put in it that your trademark secrets are going to expire. They don't. Those are kept as long as you keep them, as long as we're doing those reasonable steps. Locked doors, security, not letting the universe know about it, keeping it on a need-to-know basis. You can keep a trade secret forever. Coke's got one that's over 100 years now. That's their formula. So please remember that. Guys, and I know one thing, any of y'all working with Maureen, she's told you this till you're blue in the face. And guys, I'm so sorry. I had to set on the weird view of my PowerPoint, so you guys have been having to look at that rough one. I'll see if I can fix that. Ah, there we go. Sorry about that. But one thing I want all of you to have is a corporate entity. If you don't have a corporate entity, you are literally playing with fire. Maureen, before you moved to Greenville, I had done a presentation over at Next, and it was about this time. It was roughly September of 2018. And I love telling horror stories. Y'all can tell that, big horror fanatic. If you guys have not watched Lovecraft Country, get on that. It's pretty cool. But this horror story is even better because it's real. We had a lady who had a hair salon, and she was up in Spartanburg. We're there, and of course, I asked the trick question. It works so much better in public because I can see you and in person to say, who has intellectual property? Nobody ever raises their hand. It's a beautiful trap. She didn't raise her hand, but as we were in this meeting, she had an electrician and a drywall person working on her hair salon, and yet she didn't have a corporate entity set up. And I said, okay, here's what's going to happen right now. Your electrician's up on a step ladder. The guy putting in the drywall left a screwdriver on about the third step down. Your electrician is now going to fall, but he's going to grab the live wires to catch himself, because that's what you do when he falls. You try to stop it, and he's going to fall on top of the plaster guy. They're both now critically injured. You don't have an LLC to prevent them from suing you personally. I have never seen a person turn that pale in their life. This was about 7:30. She was in a panic, wanted to get a hold of the Secretary of State at 7:30 on a Thursday night. That's not going to happen. And so she literally sat there and sweated the entire meeting because, and I had her call. I was like, look, just shoo them away. Tell them go home. But guys, it is that sort of situation we're looking at. If you don't have a corporate entity, you're personally liable. You can sit there and hold your little wallet up or your purse or whatever you may use. You can wave it at the camera. And if something bad happens, You can open it up, and you can open it this way, and y'all can tell I don't have any money. I've already been sued. But if you hold that out to somebody, and that's the only thing you've got, you're doomed. They're going to drink your personal finances. They're going to ruin you. You're lucky if you get into bankruptcy. You want a corporate entity. I cannot stress that enough. I'm talking an LLC. I'm talking something other than a partnership. A partnership is not a corporate entity. Partnership's kissing your sister protection. It is no good. Do not do it. Set up an LLC. It's like 150, 175 bucks, folks. It is not rocket science, but it is damn good protection. Have your corporate entity own that IP. Can't phrase that enough. I absolutely want them to own it. Patent versus trade secret. These are axiomatic. You know, we talked about the universe of IP being sort of this amorphous fog. Patents and trade secrets, they're juxtaposed to one another. They may have some overlap, but in essence, they're very different. You know, a patent's a mechanical invention, a product, a widget. It's this clip. You know, it's whatever you guys may have. You know, Tina, you may have some sort of educational program set up. We can protect that too. It can cover methods. So patents cover those. But guess what? If it's difficult to replicate, like if I could hand this to somebody, and this is a bad example, this is very easy to replicate. If I want to protect it, I have to get a patent. I can't keep this a trade secret because the first time I sell it, everybody will be able to reverse engineer it. It won't take long at all. But if I've got something hard, like the Coca-Cola recipe or the KFC secrets, then guess what? Maybe I lean toward trade secret because it's cheap. If I use reasonable protections, it lasts for infinity. It's kind of hard to beat that price. Also, patent's slow, guys, and it costs money. I mean, they're expensive, and I don't want anybody going in thinking, oh, well, you know, I'll have my patent done in 6 months. We'll file a provisional, and in that 6 months, I'm going to be hounding you to get out there in the market and make certain, hey, is there justification to file the big boy utility? Are you getting market share? Did you make that prototype like I asked you to? Have you gone out there and actually tried to obtain it? Because I can get you patents to hang on your wall all day long. That's not what a small business needs. A small business needs IP protection that protects that product that they're making and prevents competitors from getting too close to it. And so that's why I wanted y'all to always haggle. When you go into somebody and they're like, hey, we should file utility immediately, there's certain situations where that's applicable, but most situations, especially if we're still in R&D, the magic word ought to be provisional application. Should always be provisional in that situation. And if you don't have a prototype, it's absolutely the magic word. Also, guess what? Trade secret protection, guys, should have been put in place 3 days before you met me and Marine tonight. Because if you're not, there's a risk that you're walking around with a wheelbarrow of holes in it trying to carry water. I want you guys to know that it has to be done. It has to be done right. It doesn't have to require an adamantium vault and security guards. You can make certain that your files are security protected on a computer that's got a password on it. If you have print materials, put them in a locked file cabinet, lock the door when you leave. You know, don't leave them out on the desk with the receptionist. You know, Fred, the receptionist, doesn't need to know your trade secrets. That's not part of his job. But again, and everybody's done a really good job of asking about policies tonight. If you have multiple employees or more than one, you will have a trade secret policy that says, hey, I, Tina, or I, Robin, or I, Michael, I'm going to expose you to things. I, Lindsay, or Karen, are going to tell you secrets, and you are now signing that I'm telling you this. And you're also signing that you know they're mine. And guess what? We can put those restrictive covenants in there with those employees as well, as long as they're reasonable. And we can protect this in a lot of different ways. But if we don't have those writings, we don't have any protection. Also, another thing, guys, and you might think I'm being silly, Bush's Baked Beans. Remember that treacherous hound dog that always wanted to sell the secret recipe? Little secret, there was no damn recipe. There was no Bush's Baked Beans. They had beans, they had brown sugar, they made them. That was it. There was no secret formula to it, but because they said there was, they cornered 83% of the baked bean market, which isn't bad for selling beans. So I want you guys to know that aura of mystique is a real thing. I want y'all to absolutely consider what that looks like, what it looks like to a venture capitalist. Because, you know, you go in there with your ducks in a row, you go in there with your patents filed, your trademarks protected, your non-competes in place, that prototype sitting there just ratcheting it away on the table. Guess what? You look really cool. And then all of a sudden you can say, in addition to the patent, we've also got proprietary trade secrets on the way that we build this bad boy, as well as our sourcing services, market expansion plans, blah, blah, blah. Guys, it adds. It all is cumulative. You know, Napoleon had a great quote. You know, the British would raise on him all the time, say, hey, you've got a bunch of civilians. Well, Napoleon would turn back to him and said, look, quantity is a quality all its own. That counts for IP protection. It counts for your ability to show that your sophistication to a venture capitalist. All of this layers upon itself. Questions, guys? Good breaking point. We're halfway through. Y'all are making it. You're doing well. Marvel's asleep. I can kind of tell. But I want anybody who has a question right now. Now's a great time. Ask us.
Dale, back when we were talking about NDAs, he actually wanted to know what the general cost is of an NDA.
Sure. And the non-disclosure agreement's about like an assignment, Dale, about an hour's time. And again, you'll want a Word version of that because guess what? You don't want to come back to your attorney every time you want one. Get a Word version. And again, I'm not telling you guys monkey with the legal language, but you can put in the name of the person. You can put in their address. You can put in a description of what you're showing them and attach maybe a description or a synopsis to the agreement. But again, about the price of an assignment, about an hour's time.
All right, we have another one. What's the cost to get trademark and or a patent? From John.
Awesome, John. Great question. For you guys, and I don't know if other attorneys do this, but I do give a break to score people because A, I know you're a small business. B, I know that you guys don't want to be paying attorney's fees. And C, I know we're expensive. Trademark should typically run you about, call it $850 for the attorney's time. There's a government fee of roughly either $225 or $275, depending on if we can make your square peg fit in a square hole at the USPTO, i.e., do they have a description of what you do, your goods or services that you're okay with? If not, we raise it to $275. We become our own, basically, scrivener, and we can write in, like, let's say that Maureen has a business that makes CBD enhanced beauty products. You're not going to find that at the trademark office. So we pay $275 so that we can say we're CBD-based beauty products, namely lotions, moisturizers, yada, yada, yada. But let's say that we make tires. We absolutely can pay $225 and click tires, and we're good to go. Patents, great question. Depends on the complexity. A provisional patent is going to run you about $3,000, $3,500. And that's why I'm telling everybody now, they're expensive and they're slow. But I want y'all to understand it's the strongest form of protection you can get for a widget, anything you make, or anything that can be reverse engineered. You want a patent. First to shelf can be tried. If you get out there and you're aggressive, you have a great product, sometimes that can work, but you also don't have any protections against somebody reverse engineering you. Amazon looking that they can do it better, faster, cheaper, and the next thing you know, they're on the shelf at Walmart, you're not. So again, roughly for a provisional, it's going to be about $3,500. A utility, and the way I split it up for clients, and again, I want y'all to haggle. You know, a couple key tenets tonight is we don't take anything from the internet, we don't take documents from the internet, and we haggle. We're now hagglers. All of us are negotiators at this point. And what we want to haggle on is, hey, you know, what's my price range here? Where are we? Because trust me, attorneys are not static. There's not some magic number that comes down from the heights that says thou shalt charge. Go in there and negotiate with somebody. I have clients do it all the time. I love it. I think it's fair. I think it's a good way for y'all to get better at it because you know what? As a small business person, if you're not haggling, you're probably losing out on cost. You're losing out on profit. You're losing out on opportunity. I want y'all to become hagglers. That is the one gift you can give me and Maureen tonight is y'all going to get more aggressive about haggling terms, haggling prices, haggling opportunities. But pricing for a utility depends on the complexity. If we're talking about a genetic material, man, we're talking 15, 20 grand. I'm talking like genetic sequences, full-blown, using peptides to cause an effect in the person. If we're talking about, hey, I have a very cool mechanical widget, you're looking at about $7,500, and y'all, I'm counting the provisional wrapped into both of those costs. So that initial $3,500 will generate a total of about $7,500 for a mechanical application, meaning we've got a simple clip that does something simple. We've got a new version of a coat rack that does your tie for you. Things like that, simple mechanical, about $7,500. Computer sciences, a little harder to get those, but they're also a little more complex. Those jump up to about 10. Sophisticated, we're talking extreme mechanical complexity, biological or chemical complexity, looking at 15 grand. So just understand that those are the prices for making the patent. Another price is once we file the utility, not the provisional, but the utility, we're going to go into a negotiation process with the patent office. It's called prosecution, and it's not like you're being prosecuted for a crime, it's you prosecuting your patent with them. And so what we're going to do is we have essentially a negotiation, because remember, we're all hagglers now. We're going to negotiate with the patent office on our claims. I filed one today for a company down in Columbia, Railmo. They have a very cool one. Guys, if I tell you about something, that means it's been filed, their application's been published. You guys can go to Google right now, check out Railmo's trademarks. You can check out their security device because it's public data. And that's another thing I want you to know. That's the antithesis of the trade secret, because when you file that patent, either at 16 months from filing or when it issues, because you can ask them not to publish, and there's certain side effects of that, it will become a public document. It will be out there. You can go to Google Patents and read it all day long. That's okay. But Railmo's device, today, I had to negotiate against 2 different patents. And they were security devices, essentially. What Railmo does is they secure the wheel of a wheelchair. You would not believe how much money Prisma, AnMed, all these other, St. Francis, all these hospital systems lose in a year due to wheelchair theft. It is crazy. And so they came up with a way to be able to log these. It's going to use a system, and you'll be able to assign an identity to that wheelchair and track it throughout the hospital, and you'll have these essentially return bays that will allow you to log it. That's their invention. And so today I had to haggle with respect to 2 different patents raised by a patent examiner. That runs about $2,500 because you've got to look at those patents. You've got to go back and look at your device, and you've got to figure out, hey, what do I do to that claim language that gives us the best shot of getting an issued patent that's a broad, good patent, not one of these little narrow, hey, my wallet's brown, it's 4 inches by 5.5 inches, blah, 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 so narrow that Maureen literally paints a red dot on it. She's essentially around you. That's the LegalZoom way of doing it. That is the very narrow, horribly precise, not going to have much coverage way. But that pricing on it, guys, is a spectrum. Trademark should run you around, $850 if somebody's getting a benefit. It can run up to $1,000 for the attorney's fees. Government fee is going to be either $225, $275. If you do a good trademark search, there shouldn't be a lot of prosecution. You might have 1 round if they raise a mark. Now, if you know that there's similar marks, and one thing I'll tell you as we walk into the trademark do's and don'ts here is that I don't want you emulating somebody. I don't want somebody here being Apple with 1 P. I don't want somebody here being Coca-Cola using K's. I want you to go be your own person. That whole UBU thing, it is a perfect golden rule for trademarks. Because guess what? Everybody in here basically early on said, I've got a business. You all have at least 1 trademark. How do your consumers know to come back to you? That's your trademark. Maybe it's your phrasing. Maybe it's that logo, like Maureen designed ours for the tanning bed. That one that we have, that's how people know you. That's how they know to like you. Your services, your products, your goods, they know it. Because guess what? I don't have any cans in here right now. But if I had a Coke can and I hold it up, everybody in here is having one. The chances of you not having a Coke and not knowing instantly what it tastes like are about infinitesimally small. But if I hold one up, you'll know. Actually, hold on. I do eat at my desk a lot. Y'all make fun of me. Can you guys see the tuna can? I'm hoping so. I got Maureen laughing, so that counts. But guys, this right here is a trademark. And guess what? It's on their tuna can. And so if you guys have any products or services, there will be a mermaid in your lexicon that is your trademark. And I want you to know that if you have them, it's best to protect them. Because in this day and age, the concept of somebody staying entirely within the realms of South Carolina, especially with the internet, Amazon, it's almost non-existent. It would be almost impossible to make it happen at this point. So you want a federal trademark that protects you not only in South Khaki, but allows you to grow elsewhere, as well as prevent somebody from saying, hey, well, they're Apple with 2 Ps, I'll have 3 Ps. Because once you get that federal protection at the trademark office, you've got the ability to block similar marks without you having to do a thing. The trademark office does it for you as part of the, hey, we don't want marks that are so similar that consumers don't know where that tuna fish comes from. Also, something else, depending on your business, guys, it could be a horrible idea to have a name similar to another company. I have a nursing home client that has they got a cease and desist letter from another nursing home saying, hey, we see that you're getting ready to open this facility called XYZ. We have facilities called XYZ, and they had one deep down around Hilton Head. My guys were thinking Midlands, maybe upstate. And to me, they called and said, well, we'd like to fight with them on this. I'm like, why? Because if we have a nursing home, and especially in this age of COVID, when God forbid governor sends sick people to it and bad things happen, if we have a nursing home and something happens to a patient, I don't interview with a name remotely similar to those guys in Hilton Head. Because consumers now, they don't even have a 7-minute attention span. They've got an almost infinitesimally short one. And if they see, hey, that was, Seacrest Acres home where that person died, well, your Seacrest farm or your Seacrest city or your Seacrest refuge up here in Greenville, they're not going to come to you. And rightly so, because they think you're associated with the Seacoast Acres that just put somebody in the ground. Now, I realize that's an extreme example, but product liability is the same thing. If you have a product and you have a name that's similar to somebody else, their products are bad. Let's say they make teddy bears filled with razor blades. You just make normal teddy bears. If your name is similar to their name, consumers aren't going to try to buy your teddy bear and run the risk of it being full of razor blades. They'll just be like, nope, if it's anything similar to that, I'm not going to do it. You can't make me. So your names need to be unique. And if they're not unique and maybe you're a little close to somebody, maybe you need to rebrand and think, hey, what do I do to distance from these folks?
Doug?
Yes, ma'am.
I have three. Well, one is a personal question, one is a trademark question, and Marvel wants you to know that this is valuable information and you are an engaging panelist. He's just absorbing it all in, and he promises he's awake. I believe you called him out a little bit earlier. So
I'm glad you woke up, buddy. You missed the part about the cartoons, man. But I do appreciate that. I mean, it's part of the reason Maureen and I. But Maureen, what are the questions?
Okay, I'm going to go in reverse order because this first one's about trademark. Is trademark protected nationwide, statewide? What about global? From John.
Awesome question, John. I love it. You're going to hate this answer. A state protection is a state trademark. That's like kissing your sister. It's like not getting an assignment. It's a bad thing. We don't want to do it. State trademarks are only taken in extreme emergencies. I've had to file some for Anderson University because there have been people beat them to the federal level, but we wanted to protect things in the state. So I have used them before, but I'm disinclined to do it. But they can be state, federal, and global. Here's the rub. If you want federal and also knock out state, just file one at the PTO. File a trademark, a federal one. You get the U.S., all of its territories, and South Carolina, and don't have to worry about that nasty state trademark. If you want global, I suggest that you know where your market is. I just had to price some trademarks over in the UK and India for a client. They're thinking these may be the areas that they go to. I'll tell you this, though. Until you have market presence there, don't worry about going foreign. Stick with what you do here. Now, if you're already in Canada and Mexico, then yeah, let's absolutely look at protecting those marks, because a U.S. trademark and a U.S. patent and a U.S. copyright are only good in the U.S., meaning that now copyrights are a little bit broader, so I painted with too broad of a brush on that one. They can get foreign protection due to treaties, but patents and trademarks, If you want to protect your patented article in Japan, you got to file a patent in Japan. If you want to protect your trademark in Japan, you need to file a trademark in Japan. But if you want to protect the entirety of the U.S. and the territories and everything else, you file a federal trademark at the Federal Trademark Office. You get all of that, plus good old South Khaki included. I would not file a state trademark. I mean, they're very cheap, but you kind of get what you pay for. It doesn't have big protection. It doesn't fend off other marks. If somebody differs very little from it, they can get a mark that absolutely wouldn't have been allowed federally. So no, don't do a state trademark unless you just have to get something protected. Federal is the way you want to go. Go global once you know that it's going to be justified with market success. That yes, I'm selling product in Canada. Yes, I'm selling product in Japan. I want to go there. Great question.
All right, Robin. So good evening, Doug.
Hey, Rob.
You actually did my patent for me, but my IP is not protected, ? I don't believe, ? Also, I need an assignment. Can you help me with that?
Yes, I can. Robin, tell me what your patent is. I think I know who you are, but tell me. I'm just seeing Robin.
Should I make some music? Dun, 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 dun.
That's right. Now I'm putting you on the spot, Robin. That's how this game goes.
Oh, there you go. Girl Go Cook, LLC.
Gotcha. Girl, go cook. Hi, Robin. All right.
That's fun. And we have another comment too.
Okay. Read the comment, then we'll go back to Robin.
Okay. Oh, sorry. Didn't mean to interrupt you. Lindsay, if another company overseas, UK, has the same or similar name but sells different products than I do, should we worry about that name similarity?
Great question. Robin, back to Girl Go Cook. call me. We'll get this set up, and absolutely can provide you with what
That's
you need.
awesome.
Hey, let me give you all my direct phone number before I forget, because it's Thursday night. 864-552-9375, and I realize I'm poking the screen. 864-552-9375. Robin, call me. All right, Lindsay, awesome question. Here is our rub. If they didn't file in the U.S., doesn't matter, because trademarks and patents are territorial. They're just like an angry honey badger. They've got this little area that they're deadly in. Outside of that area, you're awesome. So let's say this is a UK company or an Indian company or a Japanese company. If they're not in the U.S., then for you, maybe that's a good thing. But I'll tell you this, if they're in an area to where people might be harmed from it, stay away from those names, because I don't care if they're in Japan or if they're in Europe or if they're in Mexico or they're in Canada. I mean, the neighboring countries being worse because we have such a free flow of product. But if they are in an area to where somebody might be harmed, it's probably not a good idea to be close to them. Now, I'm not saying you can't get a trademark. You absolutely can. But, you know, if they sell a product that you're like, yeah, I don't really think this is going to blow up and kill too many school children, and you're like, okay, I'm willing to take that risk. If they're not in the U.S., it doesn't matter what they sell, because you file first here. Now, trademarks, patents, guys, first to file. That means whoever gets a foot through the door first wins the foot race. You're there first, you win. So they might have been using it for 100 years in Europe. But if you file in the U.S. and then they come later and try to file it, they can't do it. You've got to file in those countries when you're ready to protect. And so if you see them and they're in Europe and they're doing all kinds of stuff, you know, if it's something like, you know, a bus company to where, hey, if they're bus racks and it can harm your business, don't be similar to them. You know, if it's the teddy bear company and they make teddy bears with razor blades in it, we don't want to be similar to them. But if it's something to where you think, hey, you know, they're doing this thing and I'm doing a different thing, and I don't think there's going to be a lot of potential for consumers to develop a hate for me, then you can file in the U.S. if they haven't. You want to do what's called a trademark search. That should be part of the price that is included. You know, we mentioned earlier $850 to about $1,000. That should include a search. One thing Robin can tell you about this, because we searched trademarks for her, and we went out and looked to see, hey, you know, what can we protect? What's out there? Because, you know, Girl Go Cook is awesome, but you know, what if there's a Girl Go Cook who makes food down in Atlanta and they're no good, and they're also known as House of Botulism on the internet? You know, we want to do a search to know, A, what's out there, because if there is a Girl Go Cook somewhere else, we can't be Girl Go Cook. We don't want to be Girl Go Cook. But if there's not, then we absolutely want to file that quickly. And a lot of people are like, oh my gosh, do I have to be using it in commerce? You don't. We can file what are called intent to use applications. File those all the time, guys. What that says is basically, this is my trademark, or maybe you have Marine do a logo for you. You can attach it on there and say, I'm going to use this with umbrellas. Not doing it yet, but you have 3 years from when that mark's allowed to be using it with umbrellas. If you don't use it with umbrellas in those 3 years, you can lose it. But 3 years is a long time. And one thing that you guys want to do, and again, I told you, you want attorneys to do patents and trademarks because of the docket. That is critical, guys. We keep aware of these dates. We keep aware of these dates. We hound you about it. I mean, I literally sent out emails first thing this morning going, where's my review of this patent? Where are we with the specimen on this? Because if I don't do that, life gets in the way. You know, you turn around and all of a sudden you're driving somebody to USC to go to college and you swear you just picked them up from the hospital yesterday as an infant. So what we want to do is to make certain that we do that search and make certain you're clear. And if we get a clear search, go for it. If we see marks that are close, there may be options. So don't feel, oh my gosh, you know, my cool mark, there's something similar. There may be things we can do. As y'all probably are getting the hint, I love to argue. I love arguing about trademarks. It's fun, and it's a way to kind of negotiate. But I have to tell you going in, I don't control the examiner. So if we have marks that are similar and we know that we're in for a fight, we may lose the fight. The best way to win the fight is to make certain there's nothing close to you. Or let's say that there's a company called Acme that does refrigerators. Well, if we're going to do hair dryers, there's probably a pretty good point, or tires. There's a really good point that we can get Acme for tires versus a refrigerator. So we may be willing to take that calculated risk, understanding nothing's guaranteed, but we have a good shot at it. But that is an awesome question. Any other questions, Maureen?
No, but I mean, Robin has put it in capitals. A shout out. Doug is great at this, guys. Let him help you, please. You will not regret it. So we need to take this moment. Compliments to our speaker.
That now is being used against me. That is terrible, Robin. That is just terrible.
Yeah, that's awesome.
Hey, thank you though, Robin. That's very sweet. But guys, don't feel that you have to use me. SCORE is not saying use Doug ever. If you know an attorney that you like, go to them for a referral. I don't want you to sit down with that person. I want you to at least do a Zoom and see how they react and talk to them, because in this day and age, there's no excuse for not being able to say, hey, I vetted my attorney via a real quick video conference call, you know? And if you need a referral, you know, it's awesome that Robin tells y'all to use me. I greatly appreciate it. But if you know somebody, ask them for a referral. That's a really good way to know, hey, A knows B, so I'm okay with B because I know A and I trust their judgment. But guys, let's march back on into copyright a little bit. Copyright is a horribly broad protection. And what I mean by that is it covers everything from a jeweler to an architect. It covers everything from a sculptor to a software engineer. It is a very broad, horribly underestimated form of IP. It covers your website. It covers your plans. Now, Tina, I think you said you were in education. Guess what? You know, when you create those educational plans, when you create those curriculum, when you create those textbooks, copyright. Copyright, copyright, copyright. You may have a trademark for your company, which is going to be that brand that everybody knows and comes to. But copyright is going to protect the substance because it's not patent, because what you've done is created an original work. One thing as far as big mistakes, and we've already covered some of this, and if we have, I'll go through it fast. But guys, don't you ever set up and start using a trademark or go get your business painted on a truck or open up signage without doing a check, because you don't understand how many times I've had a client roll in and go, hey, I just bought this website and I just spent 10 grand on this website company and these marketers, and I've got a website, we need to protect it. I'll go and find out that there's one very similar to it in a similar industry and we can't get it. So do not put the buggy before the horse. What we want to do is we want to check, hey, you know, did we clear this blasted thing? Did we get it so that we know we're okay? Because if we did not, that is a bad problem for us. And again, do that before we buy signs. Do it before we pay for the website. Do it before we pay for advertising. You know, guess what? When you register with the Secretary of State, you need to make certain that name's clear. You know, you need to say, hey, you know, is my name distinct enough so I don't have to worry about being confused with Shady Acres that just took 15 patients in the ground last week. We want to make certain that you are on an IP level and on a consumer level, your own person. You do you. Also, don't try to get too close to somebody. If they're Apple, you don't want to be apples or applesauce for computers. Again, guys, there's that magic word assignment. I cannot overstate it. If you don't have an assignment for a copyright material that somebody else did for you, you just own the one iteration. Remember, I paid Maureen $500 and I paid Jennifer $500, but I just got that one image of the tanning salon's logo. I did not get copyright usage. I did not get an assignment, and I'm a doofus. I should have done that. Also, if you don't file for federal protection, you know, what are you doing here? You know, you're going to possibly get what I call fishbowled, and that's not a good concept. And y'all will see, I've got a bunch of beta fish over here. See my fish? I absolutely know about fish bowls, and I don't want any of you guys being put in a fishbowl. By that, I mean this. Let's say that, who asked about that? I was trying to think who asked a great question about trademarks. Let me skim through the names real quick.
I think it was John. Maybe.
John, I do think it is. Thank you. Thank you, Maureen. It is John. And John, what I want you to know is this. Let's say we don't file for federal protection. You're just like, nope, I'm just going to stick with doing me. You'll get some common law protection. Let's say you're selling around the upstate, you know, maybe you're selling in North Georgia. You'll be able to protect it in those areas specifically. Here's the problem. Maureen did protect hers. You guys are, you're Aquatic Industries Incorporated. She's Aquatic Enterprises, LLC. And she went with Aquatic Enterprises as her McDonald's. That thing's everywhere. You know, but it's not in South Carolina. It's not in North Georgia yet. But what happens is she filed a federal trademark, and then she moves to Greenville. And she also opens up a small satellite office in Gainesville, Georgia. And so now all of a sudden, she's right there with you. And she's going to send you a cease and desist letter saying, hey, John, love what you've done with your mark. Sarcasm, sarcasm. But she's going to tell you, guess what? You either need to stop using it completely. And that's probably what they'll demand first. Because remember, we're all hagglers. We asked for 10 to get 5. We asked for 7 to get 3. We're going to haggle. And they're going to tell you, John, drop dead, stop using your trademark, blah, blah, blah. You'll go to an attorney and they'll be able to say, hey, John, you've got some common law protection. Again, worse than a state trademark, which is hard to believe but possible. But it's kissing your sister protection. You're going to be able to continue using that trademark wherever you're at. Concrete example. you guys realize that there was a Holiday Inn down on the coast of South Carolina. It's that unique shaped one. There's a really cool case based on that one. And what happened was the National Holiday Inn chain moved in. They had their federal trademark, John. They done it the right way. You know, when we say federal protection, I mean it. They rolled into South Khaki and said, yo, you know, Holiday Inn over there on the coast, we need you to stop. And the Holiday Inn fought them with the court. And the judge said they don't have to stop. So they were using it first. But now y'all remember Carolina is a coast state. And they said, you know what? We're going to give you a 60-mile radius from the hotel. Half of that radius is water. Fish don't really use hotels that much. It's a pretty much narrow fishbowl of concept because guess what? They got you trapped in it. You're just like my betas. You're just like Adonis over here. You're never getting out of that bowl, man. I hope you enjoy that bowl because you're going to be trapped in it for life. And wherever your areas are in the upstate and North Georgia, that's it. You can't expand because these guys are now Holiday Inn everywhere else. Marine's not going to let you expand. If she sees you trying to expand, she may hit you for willful infringement of a trademark, which includes attorney's fees, which are horribly expensive, as well as triple damages because it's willful. Because guess what? You guys have had a little tell-tee about this before you started going into other areas. So federal protection. And again, guys, search. Find out if there's somebody similar. It's better to know now than later once you become a McDonald's, but you're based on sand.
Doug, we have a question, if you don't mind.
Absolutely. Lay it on me, guys.
This is Tina. With that example just shared with the similar names, but if the services are different, will that allow you to continue with the trademark protection? Good
question, Tina. I love that. You guys are learning how to haggle. Maybe. And by maybe, I mean, guess what? If we're Holiday Inn and we do hotels, okay? If we're Holiday Inn and we do restaurants, closer. Now, if we're Holiday Inn and we do strip clubs, this is where it's going to get really weird. Maureen's like, oh my God, what is this guy talking about? You've got to think about the nature of the business because if you're a Holiday Inn and you want to be a family-friendly place, and there's a Holiday Inn that's a strip club, guys, that is one of those reasons that you stay the devil way, but you got to police your marks too. Because if we're there, Tina, and we see that there's the potential for something to have a horrible impact, let's say you're a church, and all of a sudden somebody comes out with new age something, you're not, okay, new age CBD store or new age head shop, something you're not comfortable with, that can have an impact on your mark too. And so really your question focuses on, you know, water services that you're okay with. Because if we're Holiday Inn for hotels and they're Holiday Inn for pliers, fine. I don't think you're ever going to have an issue with them. You know, the chances that conflicting and you two being confused with each other is pretty rare. But if they're Holiday Inn, if you're Holiday Inn for hotels and they're Holiday Inn for strip clubs and come to you wanting a coexistence agreement, you're not going to do it. Because Lord forbid, you know, that right there is something that will really weigh down. It's what's called tarnishing your mark. We don't want to do anything that tarnishes the mark. We don't want to do anything that lowers the value of it with competitors. And so if we had somebody approach us on that, or worse yet, they just opened up, you know, you're down on the coast, you're Holiday Inn, you've got a federal trademark, and you see that all of a sudden there's a Holiday Inn strip club up here outside of Greenville, you're calling your attorney the second you see it and saying, look, we have to stop this because that is something that can denigrate your trademark and you don't want that to happen. But let's say that they're a tool store, maybe you don't care and maybe you're okay with it, but you have to do a balancing of the factors here. What am I okay with? What am I not okay with? That's a very good question. Guys, copyright mistakes, assignment. This should be a word that y'all have in your nightmares tonight because if you hire a Marine or you hire Jennifer and you only pay them but don't get an assignment, you don't own what they created. You own the one iteration. You bought the Mona Lisa. You didn't buy the rights to go show the Mona Lisa off or to make copies of the Mona Lisa or to sell the Mona Lisa to other people so they can do those activities. You bought that one version of it. Sure, you can crumple that up and throw it away, and sure, you can have it at your house, but public display is a copyright principle. If we have it, you know, it's Maureen and Jennifer who own that tan logo, not me. I paid for the logo. I have that one iteration, but I can't go put it on a billboard because that is a public display. And until I get that assignment, it's Maureen and Jennifer who own those rights, not me. So guys, assignment. If not, you just bought that one item, and that's all you can do. Never copy somebody else's stuff. Don't go to a website and pull information. Don't go pull images. Guys, again, I have a lot of bad scenarios because this gray hair is not just from the kids. But I had one of our local politicians was hit last year. They'd set up a website trying to show what a particular system is going to look like when it's in place. And I'm not going to embarrass anybody and I'm not going to tell details. but they used a picture in a literally just a missive sent out to their constituency going, hey, there's a potential that this system is going to be in place at these locales soon. Here's what one looks like. That's all they said. Nothing else. We got a cease and desist letter and a demand for $10,000. And that's one with 4 zeros behind it and then a decimal for $10,000 for a picture that I literally was like, my God, this looks like some fuzzy thing you'd snap on your phone by accident as you're trying to call your sister. But this was a case to where this person had registered and filed a copyright registration on it. They owned that particular image. Our people had used it, put it out there in public. We settled it for much less than that. But guys, we had to pay something. And so that's why I'm telling y'all, don't copy. Absolutely never copy. I don't care if the website says free to use, take it as much as you want. If you didn't have a Maureen or a Jennifer created or you didn't create it yourselves, never copy anything from the internet, ever, period. I cannot stress that strongly enough. Again, if you do have things that you use, let's say that you've got a website that's awesome, and say, Tina, you've got an educational model. Let's say that you've got one, or maybe John, you've got something you've designed that on your website is just awesome. But you started to notice people are, trying to get closer and closer to it. If you have a copyright registration on it, you're the Maureen Jennifer. They can't go make a derivative. Excuse me, folks. They can't make a derivative. They can't use it in public. But if you don't protect it, you can't enforce that against them. What we want to do is to have that registered out of the gate. So, Tina, your educational model can't be used by anybody unless they have a license from you. Also, guys, written agreements. Now, when I say author, I should have put that in quotes. Because remember, Maureen and Jennifer were an author when they designed that tan logo for me because it's copyright material. Somebody who does computer code for you is an author because they're creating software which has a copyright tangible aspect to it. Someone who creates a statue for you is an author. So remember, when you see the word copyright, it means the artist. It means the author. It means the person who created that item. It doesn't mean an author is somebody who does text or something else. You need to make certain if you have a working relationship with any of these folks that there's one of these assignment things in place, as well as just a written agreement that explains what you expect from each other, what you're going to pay, when things are due. Hey, is there a late charge? What happens if you don't make a timely deposit? I want all of that handled. If you're not doing that, you're not haggling. And remember, all of us are now hagglers. We're master hagglers, and that's the one thing we're taking away from tonight. Copyright, guys, I cannot overstate how dangerous these things are. I've had clients have to write checks for $70,000 because they copied a poem off the internet that had anonymous at the bottom of it, and they thought they were okay. And I'm not making these facts up, guys. $70,000 for about 11 lines of poem. That's expensive. And the copyright artist or author was kind enough to send us back, or it was on a dish towel. They were kind enough to send us back a copy of the dish towel that had their poem on it along with their copyright registration. That gives you a gut sink feeling like you've never had before. It is not something I want any of y'all to ever have to experience. Now, we talked about magic words earlier on. Henry and guys were asking, what about assignments? What about, NDAs? They're magic words in them. Well, here are 2 magic words that are often used wrong. If there are any Harry Potter fans on here tonight, Avada Kedavra kills you. Well, guess what? Misunderstanding fair use, misunderstanding work for hire can at least maim you pretty good, if not kill your company. I do not want you guys thinking, hey, if I lift something off the internet, it's going to be fair use. Here's a quick rule of thumb. If you lifted something off the internet and you're trying to use it to make a profit, it's probably not fair use. Work made for hire doesn't mean that I paid Maureen and I get the copyright. That is the critical misunderstanding of it. Work made for hire is a very special creature that is like, designing maps, coming up with questions for a test, helping working on an atlas. Very esoteric stuff that I doubt anybody on here does, except for Jasmine. She's a cartographer and now she's mad at me. But what I want y'all to know is that work made for hire is not something you should trust. You trust assignments. You get Maureen to assign that tan logo to you. So guess what? You can put it on the internet. You can put it on your truck. You can put it on the offices. It's okay. But if you don't have that, you just paid for that one iteration of it. I told you about the anonymous. That doesn't count. If you go to the internet and it says anonymous, don't trust it. It can get you in a lot of trouble. Poor man's copyright, guys, there's no such thing. Everybody's like, oh, I've got a poor man's copyright. I'm mailing myself something. You wasted a stamp. That's all you did. Guess what? You can't ever open it. If you take it to court and open it up, guess what? Okay, whatever's in there was protected in the sense of it was in the letter, but it's not a copyright. It's not a trademark. It's not a patent. It's not a trade secret. It's nothing. So don't worry about it. Don't do it. Guess what? Copyright has this horrible little tendency, guys. It exists in time beyond the life of the author. I didn't get my assignment from Maureen and Jennifer. They're co-owners on it. There could be potential for that protection to go 95 years past whichever one of them dies last. And yes, it's a little ghoulish, but that is how the copyrights are measured. Typically, it's 70 years from the author. Joint works and unpublished works can get even longer time frames. So I want y'all to understand, you might see a poem from the 70s and thinking, I'm okay. Well, guess what? If that person's still alive, there's a copyright on it. Even worse, even if they died and it's not been 70 years since their death, there may be a copyright on it. If it was a joint work, it may go out 120 years. So be very, very careful thinking because something's old, look at this gray hair, something's old, that it's still not effective, because that is not what we're looking at here. Maureen, any questions or anything?
Yes, we have a little backlog.
I'm sorry, guys, my fault.
No, such good information. First of all, Tina says, great example, thank you. I believe she was talking about the Holiday Inn.
Oh, you're most welcome.
John, how and where do I search names of businesses so that my new company has not been, to know that the new company has not been taken? So.
Oh, John, brother. Now, this is why I like Zoom, folks. Hold on one second. I'm going to stop sharing for a second. Okay, now you're all back in my ugly mug. What we're going to do is we're going to go to the internet, that wide world of pleasure. And where we're going to go is, first of all, John, a couple ways to do that. First thing I want y'all to do is go to uspto.gov, and I'm going to show y'all exactly where I'm going. I'll share the screen here in 2 seconds if I can make that little thing come back down, which I can't. But hold on 1 second, guys, and I'll get it up. I want y'all to go, and I'm going to share the screen and do this with y'all. Okay, boom. All this is right here is the USPTO website, www.uspto.gov. I want you to go to trademarks. I want you to go to tests, and that is not the name of the cute girl, John, so don't get excited. This is the Trademark Electronic Search System, TESS. What I want you to do is to go to Basic Word Mark Search, and the name of your company is Apple. You're going to throw in Apple, and holy moly, there's 4,000 some hits. You're going to go back, and you're going to hit live, meaning I just want trademarks that are still registered. There's still a ridiculous number of trademarks. You'll see there's 1,401 living trademarks that use Apple. Now here's where it's going to get weird. If you happen to be specifically Apple Orchard, and guess what? You make candy, you can't get a trademark on this. You're done. Because there's already an Apple Orchard. They filed on August 10th, literally just filed a month ago, saying 1A, and what these designates mean, 1A means I'm using it commerce. So Apple Orchard is saying, hey, I'm making candy. We can go to it real quick if the office will abide. And guess what? They provided a specimen. This is what their candy looks like in its bag. And you'll see right here, it says Apple Orchard, flavors with chewy caramel. That's not a bad specimen. And so if you wanted to be Apple Orchard, John, we're SOL. We do not want to be Apple Orchard, because if they start poisoning people with this candy, your Apple Orchard popcorn is going to go down like Led Zeppelin. Except you're not going to have great record sales. You're just going to crash. Now, your next question was, hey, where do I go if I want to be able to see if my name's out there? Well, let's go to the South Carolina Secretary of State. And this is one thing I can't actually do in person, so I'm kind of digging the Zoom aspect of this, guys. South Carolina Secretary of State. Because I'll sit there and tell you tests and all this junk, and by the end of it, you're like, what was the name of that lady he said I could call about this? But go to the Secretary of State. What you want to do is to go under Services and Filings, and then we want to go, I'm sorry, I went the wrong place, go under Searches, and what we want to do is go under Business Entities Search. We're going to click on Business Entities Search. Now, let's say that we still want to be Apple Orchard for some weird reason. We're going to put in Apple Orchard because we make car parts, and we're like, yeah, we don't really care if they poison people. That's not going to come back and haunt our Super V10 hypercharged nitrous engine. So we're going to search Apple Orchard. Well, guess what? The state of South Khaki says, hey, I have 2 Apple Orchards. I've got an Apple Orchard Inc. And when you click on this, here's where it gets ugly. We don't know what they do. We just know that, guess what? It looks like these guys, kind of cool. They actually dissolved back in 2011. So we know there used to be an apple orchard out there for something. We don't know what. So we go back, we do that search again, and we're going to go back down there to the second one, Apple Orchard Properties, LLC. Again, we click on them. These guys were just incorporated in 2019, so they're still fresh, they're still alive, and we have utterly no clue what they do. So if we see these, John, that means that we probably don't want to be Apple Orchard either at the USPTO or the South Carolina Secretary of State, because if we are, we run the risk of their Maureen or their Jennifer coming up later on and saying, hey man, you're too close to us. We're not comfortable with this. And so y'all, those are the two sites you go to check A, business entities, and B, trademarks. Trademarks, you go to uspto.gov. Business entities, you go to the South Carolina Secretary of State, entity search. Again, we don't want to be Apple Orchard. There's already a trademark for a food product. So if we're thinking we're going to be steaks and we're thinking we're going to be something food-based, you're not going to get it, even though they're caramel apple pops. We can't get it for lobster. We can't get it for steak. We can't get it for caviar. Can't do it. So we want to stay away from Apple Orchard. Same with that business concept. If that Apple Orchard goes out of business or if the IRS comes to get them, we don't want to be an Apple Orchard. We don't want people thinking we're that Apple Orchard. We want to be something different. That is a great question, John. Guys, I'll jump back into the presentation now. Let's see if it's going to let me do that. Stop share. And hey, guys, have y'all noticed how good Maureen and I have gotten about this? This is our first show, and I'm thinking we're doing pretty well, just considering.
Yeah.
And y'all don't have to agree or disagree with that. I'm just liking the way things are going. Now, guys, one thing, too, is that, if you license something that's copyrighted, that's not the same as getting an assignment. An assignment says, "Ooh, should not have done that." Sorry, guys. What this is a license is a limited aspect usage. An assignment is, I own it. If I want to go put it on the strip club, if I want to go put it on the Holiday Inn, I can do whatever I want to with it because Maureen assigned it to me. But if I license it from Maureen, she's going to set very definite articles. And y'all, I mean this for your trademarks too. If you have something that maybe a business comes to you and says, oh my gosh, John, Henry, I love your trademark. I want to go in this business too. You're going to have a written agreement, B, a license debating on what they can do, not debating, determining what they can do with your trademark usage. I don't ever want you guys to turn somebody loose. That's called naked licensing. I promise y'all it's not nearly as fun as it sounds. It means that you did not take care of your trademarks. You essentially put them out there in the woods like a naked baby. And you say, you can use it for whatever you want to. Even though I'm a church, you can use it on guns. Even though I'm a church, you can use it for drug dealing, which you can't do, that's illegal. But you get the sense of what I'm doing here with my hyperbole. We want to make certain that if we have a trademark, we do not ever turn somebody loose using it without a license and specific limitations on how they use it, what they can use it for, and a time limit. If we don't do that, y'all, that is a problem. Think of clip art. And think of when you go to these places and you get clip art from them. A lot of people want to make clip art into a trademark. You can't do that. It is specifically forbidden in their works that you can't use it to make a brand implement out of it. You can't use it to help promote your business. You might be able to use it on your website as a picture, but you can't make a trademark out of it. So make certain if you're dealing with any of this type of work that you know what you can and can't do with it, because if you can't do something with it, they may renege your license and all of a sudden you don't even have the ability to use it anymore. Self-help trademark pitfalls, guys. Choosing a bad trademark name. And by bad, hang on it. I keep punching that and I don't mean to. What I mean by bad is one that's too similar to somebody. A horrible thing that happens, guys. Fostering great ideas. And Maureen, you're new, but they're an awesome foster agency here in town. And they're not a state-owned one. They're private. David White is their person. He's their man. He just asked for a new trademark today. And part of our little haggle, notice haggle, he was in a trademark session of mine about 10 years ago now. I have filed upwards of like 35 marks for them. I don't charge them. None of you are getting that, Robin. I see what you're thinking. No, not free. But for fostering great ideas, because they're an awesome agency, they came into existence to help kids in the upstate better acclimate in foster care. We used to be savages in North Carolina, especially around the Greenville area. When we moved a child from Home A to Home B, we actually had them put their belongings in a trash bag. And all of us sitting here on Thursday night, we're all comfortable. We're all in front of an electronic device. We're comfortable. We have first world worries. Little kids in a foster care situation never, ever, ever need to be told, put your stuff in a trash bag, Because what's that equate to? You're trash. David and his guys at Fostering Great Ideas came out of the woodwork and said, we're never doing that again. They went to BMW, they went to Michelin, and they went to Milliken and said, hey, we need money to buy 500 sets of luggage. And no, we're not drug dealers. We are going to help these kids move from home A to home B, and we're going to give them control. And one thing, guys, I love my Cub Scouts. My son's getting ready to become a Boy Scout, but I can tell you this, children's egos are some of the coolest things on earth. And if you provide them with positive reinforcement, even just a little bit, you're going to find magnificent things can happen. But if you tell them they're trash, and you reinforce that they're trash, and you put them in a trash bag, and you say, put your stuff in a trash bag, Mr. Trash, we're leaving, that's horrible. That is horrible. And none of y'all would ever do that. But David and his crew absolutely fixed that. And they're now everywhere. They're actually international at this point. But dear old David, and I like David, but I'm getting ready to throw him under a bus and then back up over it. He stood up at a Greenville Chamber thing, guys, and I still remember it. It was like kind of like tonight. We're in person, we weren't banging elbows. We're all in a room. He stands up at the back of it, and y'all, this is karma. It's so funny, and this is absolutely true. All of you call David White with Fostering Great Ideas, and he will tell you this, because in turn for my doing his trademarks for free, I get to throw him under the bus every single presentation. He stood up the back and said, well, I filed my dozen trademarks. Y'all, they're nonprofit. They don't make money. A dozen trademarks just for the government fee cost north of $2,500. David, and God love him, y'all, he filed as a foster care agency. He is not a foster care agency. He is a nonprofit organization that assists foster children with acclimating to foster care life. He is not a foster agency. And so he stood up at the back of it. Y'all know me now. I'm a little aggro. I want y'all to haggle. But I was contemplating murder. He was at the back of the room and had stood up and basically said, don't listen to this guy. Do your own stuff. Kid y'all not, he was in my office about 6 months later with a stack of these dozen. And you know what we had to do? We had to scrap every one of them. They were useless. Because, guys, when you file your own trademarks, you're set in stone. It's first to file, but it's also, you don't get to make changes. If you say that, hey, my apple orchard company makes engines, and you meant to say we make filters for engines, you can't change it. You can't later go back and say, no, I'm filters, not engines. You can't later go back and say, hey, I'm not a foster care agency. I help kids acclimate to a foster care situation. It's the wrong class. And guys, do not do your trademarks yourself. Don't do it. Don't do it. Don't do it. The docket and the ability to goof these things up is just terrible. Now, what if you're too broad? What if you say, hey, why do X and Y and Z? Well, after your trademark is registered, you have to show that you do X, Y, and Z. And by that, I mean, if you said that, hey, and this is too broad, too narrow, sort of combined. If you say that, look, what I do is I do these 58 different things that are associated with engines. If you only do 2 of them, then guess what? Those 48 things that you're in there for, you have to start knocking those off your trademark, or you run the risk of having your mark invalidated for fraud. By too narrow, I mean that guess what? Maureen and Jennifer, they have an awesome marketing office, awesome. But they put in their trademark application, we make logos. They don't. They make logos, and they make copyright, and they have consultations, and they have marketing services, they have design services, they've got a plethora of things. But they filed a trademark that says, we make logos. Well, they're not really even a marketing agency. They're just some sort of design graphic. So you can be too narrow and too broad. Heck, you can, if you had 2 classes, you can be too broad and too narrow at the same time. I don't want y'all to do that. I like to file for a good, broad trademark, but one that covers what your business is going to do. Your dates of use, if you're wrong about those, or if you guess at them, and then later on it's got to be litigated, that'll come back to haunt you. And guys, again, if you get a deadline for a trademark or for a patent, they're written in stone. They don't change. You can't beg your way out of it. If you don't respond, your mark's going to go abandoned. Sometimes it can be fixed. Sometimes it absolutely cannot. Another fallacy is people think, hey, I own the website address, so I've got a trademark. Absolutely not. That is an apple and an orange. Owning a website domain is not owning a trademark. I don't care how many websites you own for Apple Orchard. That does not mean that you own the trademark for Apple Orchard. Indeed, we saw that there's already one out there for candy. So if you own Apple Orchard for restaurants, you're in a bad way because you paid for a domain name that essentially you can never use because we can't get you a federal trademark on it. There's somebody else who's already got it for foodstuffs. Again, though, failing to enforce that mark. If we see somebody doing something, using our mark in a bad way or denigrating it or using it in a way that we don't want it used in, step up. Not only are we haggling, we're proactive. We're going to see somebody doing this. We're going to pick up the phone and say, hey, I just came in agreement with, oh my God, there is a strip club called Holiday Inn. Send a cease and desist letter ASAP. Get this done. And again, I'm being a little silly, guys, but usually the people who are using your marks are not people you want using your marks. Trademark versus copyright. Again, remember that the universe of patent, trademark, copyright, trade secret, it's all sort of like a shifting fault. There's times when it's heavy in one area, but it covers all four of them. Guess what? Trademarks last forever. As long as you're using it in commerce and you renew that bad boy, you got to renew it and between the 5th and 6th year the first time. It's every decade after that. And yes, you do have to pay your attorney to do that because there's forms that you fill out. But guess what? That's why you use the docket. That's why you use an attorney, because you guys would be shocked at how many trademarks get registered and then die at the 5th year because it has to be done before the end of the last 6th year from your file. So it's not a calendar thing. It's based on the date you registered. There are an ocean of marks out there that are still used in commerce but don't have federal protection because somebody missed the date or they missed the 10-year date. They're out there all the time. And guess what? You can try to revive them later on, but if somebody else beats you to the trademark office, remember your application died. So if Apple Orchard was your mark and that guy say that there was an apple grove or an apple growery or an apple garden, those might actually block your apple orchard from coming in. So these are significant reasons to use an attorney as we do docket the stuff. I absolutely renew marks. Like Coastal Carolina has a ton of marks. They're coming up for their 10-year thing. And I just send them a list and say, hey, here's what we need to get them renewed. Here's how we'll fall. Here's when we'll do it. But guys, trust me, as a business owner, the last thing on your mind is, hey, in 10 years, I need to renew my trademark. It's not going to happen. And the USPTO is not going to try to track you down to find you to tell you about it. Also, guys, remember for those blasted copyrights, 70 years after the death of the author, 95 for a joint work, or 120, guys, if it's a work made for hire. Remember those very special ones we talked about, atlases, test questions, little weird things, or 95 or 120 for an anonymous work, meaning we don't know, it's just out there. So that's 120 years for that thing to be protected. So I don't want anybody here thinking, if it looks old, I can use it. That's the worst rule of thumb to develop. Don't do it. Guess what? Sometimes these marks have to be created if they're old enough. If they're after 1978 Jan 1, you don't have to do it. Like if you guys file one today, you don't ever have to renew it. It's as good as you want it to be for that life. They could be 70, 95, or 120. But if it's before that, because remember, these trademarks are long-lived creatures. Think music. Think albums from like the 50s and 60s where, hey, the artist is still alive. I mean, Jerry Lee Lewis, I think he's still alive, but he's still out there. So until he dies, that trademark's still going to have another 70 years beyond him. So you can't use Great Balls of Fire, even though it's an old song, because that copyright's going to outlive Jerry by at least 70 years. Guys, guess what? Magic words assignment. We have mentioned this thing, I promise you, 200 times tonight. If you did not get an assignment, if you didn't get Maureen and Jennifer to give you an assignment for that logo that they designed, you don't own it. You can't make a derivative. You can't use it on your business. You can't use it on your website. They gave you that one picture of it, and you can put that on a frame on your desk, but you can't go show it in public. You can't make a new logo based on that one. You can't do anything that shows a copyright ownership in it. That's strictly limited to Maureen and Jennifer. Your licenses, guess what, guys? Review them. If you have a license with a web developer, if you have a license with somebody that provides content for you that you use, actually go read it. Don't do the iTunes, I agree, please give me my music now thing. Go read it. Go read the IP section and figure out what you've agreed to. NDAs, guys, we've been asked several times, use them, use them, use them. If they won't sign, you don't say too much. If they won't sign, you don't say too much. Just the rule of thumb. Guess what? Our employees, we want them to sign a trade secret policy. We want them to have confidential information. We want to file our trademarks. We want to register our copyrights. Guys, that is it. Y'all have been very patient, but I'm happy to answer any and all questions that you have.
We have a bunch, Doug.
Awesome. Let's go through them.
All right, let's go in order. John, does assignment apply to an ongoing business relationship? For example, I want to hire an XYZ website designer developer. All contents are mine, but there may be different employees maintaining.
Okay, awesome question. So what you've done, and John, go back and make certain who you contracted with. Because remember, I said I want every, and I'm sorry guys, this camera's aggravating. I had it fixed and I knocked it off. But what I want y'all to know is this, that hopefully you have an agreement with the company. And so if the company's iterations change, i.e. they hired me and I left and then came Maureen and then came Jennifer and then came Marvel, if all these folks are there and your contract was with the company, you're good. But you need to go back and read it. You need to go back and make certain that it doesn't say, hey, Doug Lineberry. It doesn't say John Smith. It doesn't say, Marvel, I can't remember your last name. I'll have to look it up, Murray. It doesn't say Marvel Murray. What it says is company. If it doesn't say company, though, yeah, problem. Now, I do have a client, Simply Sewing Southern. They have ongoing relationships with graphic artists, meaning, hey, today I'm going to need a picture of a windmill. And next week I might need a picture of a cat. And the week after that, I may need designs of fish. But what they do with them is they do set up like an ongoing agreement with them with a contractual obligation to assign. And what they can do is they can attach the new works to the assignment to say, hey, I, graphic artist, understand that I've got a longevity relationship with Simply Sewing South. And that as part of our negotiation, part of our haggling, I have haggled that whatever I create for them goes to them and I'm hereby assigning it. That's what we want to have happen. If we don't have that, if we just simply have it with a single person and not the company, that's a problem. We want to go back and fix it. Use me as your straw man, folks. If y'all have an artist that you need to go back and get to assign a logo to you, say I met this crazy dude Thursday night, he's got me freaked out, please help me with this. You'll be shocked that most of them will. And I don't care if it's your mom, your brother, your sister. If it wasn't you that designed your logo and you don't have an assignment, you don't own it. And I don't care if you paid them $20,000. This is absolutely, positively something you have to go back and fix. I'm talking about the guys who write your software code. I'm talking about your website designer. I'm talking about anybody who is an author who may be in your realm of business. You need to have assignments from them to make certain you, the owner, you, your company, are protected. Great question.
John also asked, is there an annual fee to pay to the trademark office?
There is not. That's a good question. Foreign sometimes do for their patents. Usually they have a annual fee for patents, annual fee for foreign trademarks. It is not. The fee is actually at the 5th year, you'll renew it. And then every 10 years after that, the renewal fee is about $350. And it'll take you about, your attorney will probably charge like an hour's time to prepare the form, pull a new specimen, yada, yada.
Robin wants to know about the pictures on a website that you purchase. Example from the Pixel website.
Oh, Robin, we're going to have to go back and read the license, my dear. What does it say you can do with them? What does it say you can't do with them? If you're using it for whatever's in that license, you're golden. If you're using it for something that's not in that license, Maureen and I don't know you. We were never here, and this call stopped at 6:02 because we don't want you getting in trouble. Robin, what I need you to do is tonight, I know it's homework and I'm sorry, go back and read that agreement. Make certain, and I do mean rock solid certain, that you aren't using any of their aspects for things that you can't use them for.
Okay, Jennifer, I'm trying to start a small t-shirt design business. Would I need to trademark each design? I saw a Facebook.
I'm sorry,
Yeah, sorry, it's long. I saw a Facebook post where someone had trademarked their design, but she shared an Etsy post where her design had been duplicated several times. So would she have to pursue each sales for her rights?
Jennifer, that is an awesome question. Okay, multi-layered. This is a copyright trademark overlap. You know, we remember it's all fog in a globe. You don't have to trademark everything. Think McDonald's. They did not trademark McSalad because they weren't really confident in that. Sure enough, it's no longer on the menu. What I tell you to do is this. One of my good clients is Carolina Vapor Mill. And for their preferred flavors, like their big ones that are the multi-$1,000 sellers, we protect those. But what we don't do is protect the new flavors like raspberry poop, as my 11 years would call it. We don't protect that one because it may not be a big consumer hit. Now, you're asking another question. You're saying, hey, if I've got something out there and somebody tries to copy it, guess what? You are not going to trademark a design. You will only trademark it if it's that crazy little mermaid on that can of tuna fish. If it is going to be your business identifier that, hey, that's how people know who you are, then yeah, you might want to trademark that logo. You absolutely want to trademark it if it's this and it's on your product and it's going out there. But your designs are different. You are, my dear, an artist. And what you need to learn how to do is to file copyrights. Because if you copyright a design that you put on a t-shirt that you designed, not Marine, but you, if you're the artist for it, you automatically own that copyright. And if you file a copyright registration for it, triple damages, attorney's fees, federal court. Those are awesome things to have, because when you see somebody and they've copied your design, it's not trademark infringement. What they've done is lifted your unique piece of art, because remember, that's what copyrights are. They're a work of art that is in a tangible medium, meaning they took your design and put it on a t-shirt. That's not trademark infringement. It's copyright infringement. It's direct liability. Two things that we'll go into a little deeper. Patent and copyright are like landmines. If you infringe them, it's not a matter of mea culpa, I'm so sorry. It's a matter of how much you owe. Trademark infringement, not so much, because there's ways to haggle with that one. But copyright and patent, guys, they're landmines. If you step on them, you're hurt. It's just a question of how badly are you hurt. So these folks who have your designs, what we want to do is to show you how to file your own copyrights. You know, it's funny, I'll mention this. I'm doing one on that. It's for a group in Florence. We're doing a call, I think, in 2 weeks. And go to copyright.gov, uscopyright.gov. Hold still. I'll show you guys where to go. And if I can stop. Sorry, y'all. I'm still on the big screen. There we go. But what we want to do is to go to uscopyright.gov and walk yourself through this. They have a really good training module on this. And once you get down, I put a B in it, so now I'm going to some Russian copyright site. Y'all hold on. And now, seriously, be careful when you mistype. I know it is so funny. Y'all will love this. I love that this is a great mistake. I'm sharing my screen with you. Here you go. If it'll share. Come on, share screen. Okay. You guys see this, and what I put in up here was GOVB. I put in a fat-fingered B. The first thing came up are those evil little boogers from LegalZone. And then Trademark Engine. And then Trademark Plus. The place we want to go is 4th on the list, but we're going to go there. And really what we want to do, guys, is register a copyright. That's what we want to do. You can go to this site, and it's going to have some facts. You know, it'll say, hey, how do I do this? There's a way, you know, they're asking about registration times, frequently asked questions. They will explain this to you in step by step. If you're not comfortable with it, one thing that I do for clients, I've got a good jewelry client down in Columbia who file these all the time now. We met, we did one training session. We filed a copyright from here is what I want to protect to us paying the fee at the copyright office to show you how to do it. Because once I teach you that, you don't need me. You don't need to come back and pay me for everything you've got. And Jennifer, Jennifer or Tina who had the t-shirt question, I'm sorry.
Jennifer.
Jennifer, for every t-shirt design you do, you don't have to come to me and tack on some outlandish fee. You want to be able to protect this thing. If you design it at 2 o'clock in the morning, you want to be able to jump on the internet at 2 o'clock in the morning and register that copyright, because the thief may be out there at 3:45. And so there are absolute ways to do it, but you do not want to trademark those designs. You want to copyright. And what I would suggest you do is you can copyright them in a group. Maybe you've got spring designs or fall designs. You can do them in that group. Maybe you've got a collegiate design pattern. You can do those in a group. There are ways to where you do it to where you're not paying for one single design to be done. You can do what is called like a compendium or a collection, and you can file a number of them together at one time. Awesome question.
Okay, Dale, if the trademark search is abandoned when you search, is that mark taken?
It is dead, Dale. If you see it abandoned, here's the only way that might have a potential issue. What if they miss their 5-year registration or 10-year registration? They may still be using that mark in commerce. And so what we can do, if you see one that's abandoned and dead, and you have done some research and you can't find that entity, probably a good chance that they're not using it. But if you see abandoned, I want you to go to Google, and I want you to go to Bing, and I want you to go to Firefox and do searches to see if you can find that mark. Because just because it says abandoned at the trademark office, what that really means is they just didn't pay Uncle Sam his bid. And so they've lost that registration. It doesn't mean they're not using it in commerce. You might have to fishbowl them. Remember how we talked about being trapped like the betta fish in their bowl? You know, you might be able to pursue a mark, and if it's similar to that one, you may be able to get it because there's one abandoned, and it is first to file. If your mark's abandoned, you're no longer existing. You're not blocking anything. And if you want to file for the same mark, which I've had clients do before, you know, they just really love something. They're like, hey, I know this mark's abandoned and I want it. I'm like, hey, let's do some homework. Let's see if there's somebody else out there who might cause a problem. If there's not, then you can go at it. And remember, first to file wins. You might be able to fishbowl the other team.
Okay, 2 more questions. Doug, what if the error on the trademark application is done by the attorney? What protection and repercussion will we have at that point?
You come down with a great big bat. It's got nails in it. And typically, y'all, it depends on the error. Luckily, if most of them can be fixed. And again, you can refile. And it depends on it. Like if they got your name wrong, it can be fixed. If they misspell, if there's like a slight misspelling in the trademark, that can be fixed. Now, issues I've seen that the attorneys get blamed for is the client will say, hey, I meant to have you do logo B, but you did logo C. Probably can't fix that one. But there is a unique little cheat that we can use. You can allow the original to keep going along. We will file the subsequent one to say, hey, we are related to this earlier one that filed. And so we can take advantage of the first to file. And this is very informal. There is no way that you can say, I filed my first one Jan 1, 2020, and oh, lo and behold, we filed the wrong logo. Now here in September, we realized it, and we want to protect it. What we'll do is we'll say, hey, by the way, we own this other logo. And we would actually continue prosecution on it. Now, if it's your attorney's fault, the attorney ought to do that for free. And be like, hey, we're going to get this thing allowed. And then what we do is we just claim in that other one, which is probably a similar logo, probably shares a lot of design elements with it. We get the first one allowed. We slap on the number to it, then we're going to be able to say, hey, the second one's going to get allowed because, we goofed up on the first one, but the second one's similar and there we go. Now, let's say, though, they're completely different from each other. They're not related whatsoever. Just take a bat and go and bang your attorney on the head a couple times.
We have one more question, and I just want to remind everybody there is a poll, so you could compliment Doug tonight on the great presentation. I will launch that as soon as we're finished with this last question. One more question. Can I use a pen name instead of my real name? Example, Madonna, the singer, instead of her birth name. How does this work?
That is an awesome question. Do y'all know who Richard Bachman is? I can see your quotes. If you know who Richard Bachman is, impress me. All right, I'm going to give you 5 seconds. It's Thursday night. 4, 3, 1, 0. I do that for my kids. They hate it. Richard Bachman is Stephen King. He actually wrote, if y'all are Schwarzenegger fans, he had the movie The Running Man. That was a short story written under his nom de voyage of Richard Bachman. So there are absolutely ways to do it. What I would see, this is not, see the evaluation popped up. Y'all please complete that. But one thing, guys, is you probably want to get an agent and you would want to start having them work through things, because what you wouldn't want to do is to say, well, I want to be a pen name. Let's say that you're doing it under, you don't want people to know that you're a huge anime fan and that you're a manga artist. You just don't want people knowing that. What you don't want to do is to start registering those copyrights under your real name. So you're probably going to have to set up an LLC or maybe an agent or something like that to handle it. There's absolutely ways you can do it. And really what you can do is to figure out a way that we orient the ownership of that particular article to be transferred to a corporate entity. And then that way we can have the corporate entity apply for the trademark, or sorry, the copyright registration to protect you. There are absolutely ways to do it. People do it all the time.
Doug, this has been outstanding. There are compliments coming in. Robin's promising to do her homework that you told her to do.
Yeah, talk to Robin until I hear this.
Jennifer is going to file her copy, or she's a book design. Yeah, she's going to work on her copyright. Everyone says thank you. It's been an awesome, awesome class. I echo that. Outstanding, incredible information. You've been so kind to stay late at work and volunteer your time tonight to share some incredible information.
You guys are always welcome. And y'all remember to tell your friends to use Maureen and SCORE. Use them.
Yeah, well,
I mean, guys, I can't emphasize enough. They're free and they're great.
Yeah, well,
they can help you.
They're great because of people like Doug, who shares his expertise, and he's a subject matter expert. So thank you. Thank you.
Y'all are more than welcome. But the one parting thing I will ask is everybody within the next 2 weeks, refer somebody to Maureen. Say, hey, if you know something you need,
SCORE.
SCORE over the state. Remember that. It's not just Maureen up here in the upstate. It's everywhere.
Yep.
But I want all of you in the next 2 weeks to tell somebody to call SCORE. It's the only payment we want.
And
guys,
every month we have workshops like this. So we'd love for you to join us. And we thank you, Doug, so much for your time tonight.
More than welcome. Everybody have a great weekend.
Thank you. Everyone's saying thank you. Awesome, awesome.